What you're about to witness is one of the most shocking courtroom confrontations I've ever seen. And trust me, I've analyzed hundreds of trials. This isn't just about legal procedure. This is about a female prosecutor publicly calling out a male defense attorney for what she claims is blatant sexism and personal attacks. And it all happens right in front of Judge Simpson, one of the most respected judges in Michigan. Here's what's going on. We have Assistant Prosecutor Marie Tanner going head-to-head with defense attorney Mr. Doss in a criminal sexual conduct case. People of Michigan versus Cyrus Abadi. But this hearing, it's not even about the defendant anymore. It's about accusations of lying, misconduct, hurt feelings, and a defense attorney who allegedly treats female prosecutors differently than male ones. The tension is so thick you could cut it with a knife. Marie Tanner is about to drop receipts, including a personal email from Mr. Doss that she claims crosses the line. And Judge Simpson? He's caught in the middle of what might be one of the messiest professional disputes he's ever had to handle. By the end of this video, you'll see a judge make a ruling that could change how this entire case proceeds. But more importantly, you'll witness what happens when professional respect completely breaks down in a courtroom. Let's get into it.
Cyrus Abadi standing to me, right? Cyrus, please speak. Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, but I'll defer to Mr. Doss if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Doss had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Doss, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I, in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've hit a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I haven't done, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin. And I don't anticipate in dealing with other people within this field for them to have thinner skin than I do.
Okay, let's pause right there because we need to talk about what just happened. Marie Tanner just did something incredibly bold. She called out opposing counsel for sexism in open court on the record. And she didn't just hint at it. She explicitly said, "I highly doubt any of my male colleagues would have been treated the way I've been treated by defense counsel." Now, as a law student and someone who's studied courtroom dynamics extensively, I can tell you this is rare. Prosecutors and defense attorneys clash all the time. That's literally the job. But to publicly accuse opposing counsel of gender-based discrimination, that's a nuclear option. And here's why it matters legally. Under Michigan Rules of Professional Conduct 8.4, attorneys are prohibited from engaging in conduct that involves discrimination based on sex. If what Tanner is alleging is true, that Mr. Doss treats her differently because she's female, that's not just unprofessional. It could be an ethics violation. But notice what she did strategically. She didn't just make a vague complaint. She said she's been patient, respectful, and understanding more so than she would have been with other attorneys. She's establishing a pattern of professionalism on her part before dropping the hammer. And then she mentioned something crucial. There's an email from Mr. Doss that says, "Just don't think for a second that I'm not seeing right through you." That's not legal argument. That's personal. That's attacking character, not procedure. And in a profession where your reputation is literally everything, that kind of statement in writing is dangerous. But here's the kicker. Judge Simpson hasn't said much yet. He's listening. And based on his reputation, when he finally speaks, it's going to matter. Let's see what happens next.
And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Doss to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that. But this is the part I'm concerned about. "Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you." I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get—
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply, specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. And I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit here and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with him. So that might be something he might want to consider. And I'm not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will.
Did you catch what just happened? Because this is absolutely wild. Judge Simpson just said, and I quote, "I expected better from you, Mr. Doss." Let me tell you why that's devastating. Judge Simpson has been on the bench for over 25 years. He's read thousands of legal briefs and filings. For him to say he was surprised and taken aback by what Mr. Doss wrote, that's judicial language for "you messed up badly." And then he dropped this line: "I've been reading briefs for over 30 years. If I say I expected better, you can take that however you will." That's not just criticism. That's a public professional rebuke from one of the most respected judges in the state. Now, let's talk about what Mr. Doss wrote in paragraph 5 of his reply brief, the part Marie Tanner is asking to be stricken from the record. We don't have the exact language in this transcript, but based on context, it appears he accused her of lying or misrepresenting facts to the court. Under Michigan Court Rule 2.114, when you sign and file a document, you're certifying that it's not being presented for any improper purpose like harassment. If Mr. Doss's filing was more about attacking Marie personally than advancing a legal argument, that's a problem. Marie even offered him an out-withdraw paragraph 5, strike it from the public record. She's not asking for an apology. She's giving him a chance to backtrack before this gets worse. But notice Mr. Doss's response. "This is not personal, Judge. This is professional." Judge Simpson immediately shut that down. No, this was clearly personal. When a judge with 25 plus years of experience tells you your filing was personal, you don't argue. You apologize and move on. But Mr. Doss doubled down, and that's when things really start to unravel.
You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Bauer at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the barn or the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it. I put it in writing. I provided the court with the authority. What in fact I did was I did not submit an advocacy piece. I did not. I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out of with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
All right, now we're getting into the actual legal issue beneath all this drama, and it's fascinating. The core dispute is about Michigan's rape shield law, specifically MCL 750.52 joules and Michigan Rule of Evidence 404A2. These laws protect victims of sexual assault from having their past sexual history brought up in court because historically, defense attorneys would try to use a victim's sexual past to discredit them or suggest they somehow asked for it. Here's where Mr. Doss and Marie Tanner fundamentally disagree. Mr. Doss is arguing that at a preliminary examination, which is basically a hearing to determine if there's enough evidence to go to trial, the rape shield statute doesn't require defense attorneys to file a written motion before asking questions about prior sexual conduct with the defendant. Marie's position? The rape shield protections apply at prelim just like they do at trial. You can't just ambush a victim with those questions. You need to give notice, file a motion, and let the judge decide if it's even relevant. And here's why Judge Simpson sides with Marie, and frankly, why I do too from a legal standpoint. Judge Simpson said something brilliant. To say we afford you these protections here, but not here, makes no sense. Once the cow has left the barn, it's out. He's absolutely right. If you allow that testimony at a preliminary examination without judicial oversight, the damage is done. Even if it gets excluded later at trial, the victim has already been publicly questioned about intimate details of their life. The protection becomes meaningless. Judge Simpson also pointed out that this has been the long-standing practice in the county. Other defense attorneys, including Mr. Doss's own colleagues, have never argued that rape shield doesn't apply at prelim. So why is Mr. Doss pushing this now? That's the question Judge Simpson is clearly asking himself.
I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law said. That's what the court rule says, not with the defendant. That is not what the rule is. So, if I can go back once more. The very core item that's at issue is whether defense counsel, before exam, needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
This is where Mr. Doss makes a critical mistake, and it's the kind of mistake that can define your entire career. Judge Simpson asks him a direct question. If the judge says, I need a motion before you do it, what do you answer? Mr. Doss responds, I would ask the judge, what is the legal basis for making that requirement? And Judge Simpson fires back, and the judge is going to say, because I said so. Now, let me explain why this exchange is so important. In a courtroom, the judge is the gatekeeper of all evidence. Under Michigan Rule of Evidence 403, even relevant evidence can be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. The judge has discretion to control the proceedings. When Mr. Doss essentially challenges the judge's authority by asking for a legal basis, he's forgetting one fundamental principle. Judges have inherent authority to manage their courtrooms. You can disagree with a ruling, you can preserve an objection for appeal, but you don't question a judge's authority to make procedural requirements in their own courtroom. Judge Simpson's response, maybe that's because you wear the robe and you don't, is a reminder of that hierarchy. And here's the thing, Mr. Doss says, I am greatly at odds with it because there's no legal basis. But there is a legal basis. It's called judicial discretion. It's called MCL 750.52 joules, which explicitly gives judges the power to determine whether evidence about prior sexual conduct is admissible. It's called protecting the integrity of the legal process. Mr. Doss is so focused on being right about the technical reading of the statute that he's missing the bigger picture. The purpose of the rape shield law is to protect victims from exactly what he's trying to do, spring questions on them without notice or judicial review. And Judge Simpson sees right through it.
And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tana, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
All right, here we go. Judge Simpson just issued his ruling, and it's exactly what I expected. But it's also incredibly important for anyone who cares about how the legal system protects victims of sexual assault. Let me break down what he said. This court indeed does believe that the Rape Shield statutes were intended to offer certain protections to potential victims. That evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. So, what are the takeaways from this case? 1. The Rape Shield law applies at all stages of criminal proceedings. If you're a defense attorney in a CSE case and you want to ask questions about prior sexual conduct, you need to follow the proper procedure, motion, offer of proof, judicial determination. No shortcuts. 2. Your reputation as an attorney is everything. Mr. Doss kept emphasizing that his reputation and integrity are paramount. But then he engaged in behavior that Judge Simpson found personally inappropriate. You can't claim to value your reputation and then disrespect opposing counsel and the court. 3. Professional advocacy doesn't mean personal attacks. You can be zealous. You can be aggressive. You can argue passionately for your client. But the moment you cross into personal attacks, whether in emails, court filings, or oral arguments, you've lost the plot. 4. When a judge corrects you, listen. Mr. Doss had multiple opportunities to de-escalate. He could have withdrawn paragraph 5 of his filing. He could have apologized for the email. He could have acknowledged Judge Simpson's concerns. Instead, he insisted he was right and everyone else was wrong. That's not effective advocacy, that's ego. And finally, 5. Gender dynamics in the legal profession are real. Whether you think Marie Tanner was right to bring it up or not, the fact is that female attorneys, particularly in adversarial fields like criminal law, often face different treatment than their male colleagues. Sometimes it's subtle, sometimes it's overt. Judge Simpson handled this masterfully. He listened to both sides. He called out inappropriate behavior, and he issued a clear, well-reasoned ruling based on the purpose and intent of the law. That's what good judging looks like. If you made it this far, you just witnessed one of the most intense courtroom confrontations I've ever analyzed. This wasn't just about legal procedure, it was about respect, professionalism, and how gender dynamics play out in real courtrooms. I want to hear from you. Do you think Marie Tanner was right to call out the sexism angle, or do you think this was just a professional disagreement that got blown out of proportion? Drop your thoughts in the comments. And if you want to see more breakdowns of real courtroom drama like this, cases where the legal analysis meets the human element, hit that subscribe button. We're at 233 subscribers right now, and we're pushing to 1,000 so we can keep bringing you this content every single day. I'm breaking down real trials with real legal insight. No fluff, no clickbait, just the truth about how the justice system actually works. Thanks for watching Court Every Day. I'll see you in the next one.